Hello, today we are going to talk about 3 different things revolving around personal representatives. 1, what is a personal representative? 2, how does a personal representative get appointed, whether they have a will or don't have a will? And 3, how can I change who is appointed as personal representative? So, to kick us off at the beginning, what even is a personal representative? It used to be called executor or executrix. The law has changed the title to personal representative, but the duties are largely the same. A personal representative is the person that is appointed in a will if we have one, or by the court if we don't. They have 4 main jobs. Find the person who passed away's assets, value those assets, pay creditors if there are any, and then distribute everything either per the terms of the will or per the terms of Colorado intestacy statutes. I mean, what Colorado says if you haven't put a plan in place as to who gets your assets. That brings us to number 2. How does somebody get appointed? I already alluded to this, but if the person who passed away had a will and they named someone as personal representative, that's one way the person can get appointed. However, if we have somebody who passed away with no will and we're letting the court decide, or let's say it's a group of siblings, we'll say there's 3 siblings and one of the siblings has said, yes, I will run the probate, and the other 2 siblings have agreed to that, then we'd file some documents with the court in order to get the sibling who chose that thankless position to get them appointed. And of course, we would have the other 2 siblings who could have been personal representative. We get them to sign off saying that we would rather the other sibling do it. That brings us to the contentious number 3. How do I change personal representative? It really depends on who's trying to change personal representative and what the situation is. So let's say while I'm alive, I want to change personal representative from my brother Jacob to my brother Noah. It's pretty simple. I do a codicil, which is the fancy legal word for an update to my will. Boom, done. Have to meet all the formalities with witnesses, signatures, things like that, but that's all we have to do. Now let's take it back and change the scenario. And now I've passed away. Now we'll say scenario number 2 would be my brother Jacob, who I appointed, doesn't want anything to do with it. So Jacob could file a document with the court saying that he renounces his ability to be personal representative and nominates my brother Noah. And then Noah files an acceptance of that appointment and an application to probate my will and my estate. That's a pretty easy scenario. Let's do scenario number 3, where things start to get a little contentious. So in my will, I appointed Jacob as my personal representative, and he is willing and able to be personal representative. But for whatever reason, my brother Noah doesn't think he should be personal representative and wants to be personal representative himself, or maybe even appoint one of my other siblings instead. This is where things get tricky, because Jacob wants to be personal representative and I've appointed him in my will. That gives him what we call statutory priority, because I specifically named him while I was alive to be my personal representative. So in order for anybody else besides Jacob to try to get Jacob removed as personal representative, there's a pretty high bar that they have to jump over. They have to say Jacob is unfit. Jacob is going to embezzle from my estate. Jacob won't give things to my beneficiaries. He will mismanage things. Any of those things are grounds for filing with the court to try to argue against Jacob being appointed. Again, in this scenario, it's a lot harder because I'm saying Jacob was appointed in my will, Jacob wants to do it, and somebody else is trying to say for some reason he should not. I'm not saying it's impossible to get somebody removed as personal representative, but you better have valid cause to do so, or it's not going to work out and the legal and court fees are going to cost you a lot. So let's run 1/4 situation. Let's say now I've passed away with no will. Don't do that. I have no will. I have no spouse, no children, but I have several siblings, and we'll keep using the same 2 brothers, and we'll say both Jacob and Noah want to be appointed as personal representative. In this situation, we'll say that my parents, grandparents, they're also gone. So statutory priority goes to one of my siblings. Side note, I have 6 siblings, so there's technically 6 people with equal right and statutory priority to be my personal representative. Let's say the other 4 say, nope, I don't want to do it. Now, if we can get some people to appoint one brother or another, that might help sway the court's decision as to who should be appointed as personal representative. But ultimately, it's going to be up to the court. We're probably going to get drugged physically into court and duke things out for the court to appoint Jacob or Noah, or maybe somebody else because they don't think either of the brothers can handle the estate without getting too emotional. The long and short of it is, appoint somebody in your plan as a personal representative, and 2, make sure everybody knows. What's really important besides the documents is the conversations that happen behind them. A good estate plan prevents a lot of fights, like the fights I outlaid in situations 3 and 4. Don't forget to like and subscribe.